I'm very happy to be here again after some years. Well, the last time I was here, that was the European Championship in football in Poland and Ukraine, and now it's once again during the European Championship in football. Last time I was stuck somewhere on the road to Cambridge, and I had to watch the final match in the pub in London. So it will stay in my mind definitely as the thing that happened on the road to Cambridge. What I'm going to tell you about is the position, the standing of the European Data Protection Supervisor as far as this kind of synergy between different kind of regulators is concerned. You may probably know that the European Data Protection Supervisor has started this discussion on the European level already some years ago. And in 2014, there was a preliminary opinion that was created by EDPS, the opinion that we are going to refresh this year and to give the point of view of the European regulator on how to cooperate with both competition authorities and consumer protection authorities at the age of big data, at the age where the information is slightly different than it was some years ago, when the structure of both the competition regulators, consumer protection agencies, and the data protection authorities have been created. We usually start with calling ladies and gentlemen dear data subjects, and of course at the same time we do it as a kind of joke to show that we usually think about the person as a set of the data, which actually is wrong. That is a human being, that is a human person, that is the person whose dignity shall be in the core of our activities. But at the same time, there are already tools on the market, there are already tools in the hands of the authorities in the European Union and in the European Union countries to help with it. Although the European Data Protection Supervisor is not supervising the market itself, EDPS is a data protection authority for the EU institutions, which means that we are supervising the institution bodies and agencies of the EU bubble. We are also taking part in the legislation process, and we are the advisory institution to the European bubble. And in this sense, we think we may have a kind of objective look on what's going on in the enforcement procedures in different sectors of the European regulation. So the European Data Protection Supervisor wants to have a discussion about the synergy between all these approaches. You may probably be aware of the fact that last year we have created a strategy of EDPS for next years, and there are definitely 2 points in this which I would like to stress. The first one is that the data protection goes digital, which does not mean that the data goes digital, because data went digital already 30 years ago. But it means that the way we try to protect the personal data starts to be more and more technical, while we should not forget about the legal tools that are in our hand. And what is very important, we are opening the new chapter in the EU data protection. And at this point, I would like to mention that this is not only GDPR that is changing at the moment, but it is also e-privacy directive, of course. And there are also the other tools which are created for the digital single market, which are in the mind of the Commission and which are in the mind of the legislators on the European level. If so, then it means that the EU digital regulation shall be the digital regulation of the single market, of the market one and only that exists in the Europe, which then means that there should be not the approach from different angles to the same subjects, but there shall be something like an all-European approach to the problems that exist in the digital single market. And preparing the refresh of our opinion from 2014, we want to propose the creation of the network of regulatory bodies which are able to share the information about how the digital market works and what are the problems on this market, and that will be able to approach these problems that may exist from different angles at the same time. So that will be one of the points that we are going to propose in the opinion, which most probably will be presented in September this year. And on 29th of September 2016, we are going to organize the conference in Brussels, which will be dealing with the cooperation between the consumer protection, competition authorities and the data protection authorities. So the network of regulatory bodies is a kind of challenge for us. You, of course, are aware of the fact that there are the networks of the competition authorities. There are the networks of the data protection authorities. But actually, the cooperation between these networks in Europe is very, very weak. And this is the first problem that we see on the European level. Big data is big equals big responsibility also for those who are playing the role of the regulators. And while the data was usually recognized by data protection authorities as something that describes the person, we of course agree with the fact that it is at the same time a kind of fuel for the economy. And in the preliminary opinion from 2014, we already addressed some of the issues. We think that we have to understand better the value of the personal data in the digital market and reviewing the market approach and the market analysis of such kind of data. We shall also look into how to foster the privacy-enhancing technologies and consider which kind of guidance can be given on enforcement of these rules in the European Union. We have to work on the practical steps where the cooperation between the authorities is concerned and review the EU legislation according to the digital market perspective that is given by the Commission. If so, then there is a need to recognize that the personal data is actually the market asset. That's an asset which shall be approached the same way as we did so far in competition law with another kinds of assets that are generated and stored on the market. That is then the call for authorities to collaborate, identify the scenarios and the standards for measurement of the market power of the companies. The market power of the companies which start to generate the revenue by different kind of cooperation and collective actions done in the market. With the new GDPR, with the new General Data Protection Regulation, we only start the process. The personal data, as it was said in the studies that were done by the data protection authorities in Europe, the personal data are the assets for the huge numbers of market players. The web publishers, of course, those that are selling the advertisements, those that are advertising, the advertisers themselves, the platforms, which starts to be more and more concrete player on the market, and for the data brokers, which are often not seen as the main players, but which starts to be a kind of trusted third parties for the players in the market. Then, with the reform of the privacy law and with the data protection law, the authorities shall cooperate in order to find all unfair use of the data, or unfair ways of profiling the people, and or unfair ways of reuse of the information that was collected for one purpose in order to in order to assess the persons and in order to offer the goods for them. We are aware of the fact that such actions start on the practical level in some countries. I was not at the previous days of the conference, but I heard that you had very precise presentations of what's going on right now in Germany and France, and also in the Netherlands and Belgium in this field. However, we see that the Commission communication on online platforms, although it recognizes the cross-border character of these platforms, it does not call for the concrete actions and the concrete international approach from the authorities. Instead of that, the data protection authorities have seen the problem and have called for this kind of cooperation at the spring conference of data protection authorities that happened a few weeks ago in Budapest. And in the Budapest Declaration, we said that the greater dialogue and information sharing with other regulatory bodies responsible for safeguarding the rights and interests in the market shall be seen. And one of the ideas how to do it is to create the digital enforcement clearing house. The network of the organizations and the space to exchange an information about the actions that are taken on the national level and on European level, in which we will be able to create the infrastructure actually to cooperate for the data protection authorities, competition authorities, and the consumer protection agencies, and also for the civic society. Big data is the big responsibility, and this is also the big responsibility for the regulators, who shall not only look at the data field from the personal data protection angle, but also from the typical market perspective. And let me make it as the introduction to the further discussion that is going on during this panel. Thank you.